quick presentation regarding contracts. So if you're in this group, more than likely you have a general understanding of contracts. You understand that as a small business owner, an entrepreneur, you don't always need contracts, but I highly suggest and highly recommend that you have a contract in place. Contracts will give you so much protection in ways that you never really understand until it's too late. So what this presentation is going to do is we're going to go over just a few contracts, just a few general information, the difference between certain contracts, when to use certain contracts, and essentially explain why contracts are the backbone of business relationships and how to navigate agreements with confidence. Kind of briefly went over this, why contracts are essential to every business relationship. The anatomy of a sound contract, the difference between a formal and an uninformed agreement, essentially the difference between something written and a handshake deal. What are common contracts that every business should have? Non-disclosure agreements, partnership agreements, service agreements, independent contract agreements, equity agreements, to name a few. The basics of negotiations, as well as a few case studies of when contracts helped versus when contracts, the lack of a contract failed the business. And, we mentioned this as well. Who's this for? This is for you. Early stage entrepreneur, early stage founder, a side hustler, someone who has a 9-to-5 and wants to make money on the side, someone who is a creative or a consultant and they're forming new ventures, anyone who's navigating partnerships or funding or customer contracts. This is exactly for you. It's going to help you understand what you're getting yourself into. It's going to help you understand what are the key points that you need to know in order to properly navigate this industry, properly navigate this field, properly navigate this business section. You want to walk into it with confidence because people can, sharks can smell the blood in the water, and we want to make sure that you're not a guppy. Why it matters? Contracts are more than just paperwork. They're your shields and your roadmap. They help you to define the relationship. They help you to understand the partnership between you and the person on the other side. And ultimately, if anything goes wrong, they are the rules that are in place to make sure that both parties are playing by them. And if someone breaks the rules, then they tell you exactly what the consequences are. There is no guessing. There is no enforcing. There is no, you have to feel bad because you don't want to hurt this person, or this person feels bad because they want to hurt you. You guys signed up to these rules. You agreed to play by these rules. And if someone breaks the rules, that, you guys already knew what the consequences were beforehand. So we're going to go ahead and start with NDAs, non-disclosure agreements. So with NDAs, these are meant to protect confidential information that you share with your partners, your vendors, or investors. This includes studios or production companies if you're creative. This includes investors if you're a startup and you're looking for funding. This includes an idea if you're an individual and you're trying to start a business with someone and you want to share this concept with them. Those are scenarios when you would use a non-disclosure agreement. The key terms are going to be scope of confidentiality. You want to make sure that the exclusions of anything that should be considered confidential information is clearly defined. How long is this agreement going to last for? What areas of the country should this agreement apply to? And what is the general process for getting information to become confidential? A common mistake that you'll find with people who don't have agreements or NDAs, or even people who try to do these on their own using AI, is, typically those clauses are overly broad. They're not specific enough to the very issue or the very problem that you have. Sometimes if something is overbroad, it's hard to say if the particular information that you're trying to claim is confidential really fits underneath the definition. So you want to make sure that it's clearly defined, and as well as how long is it going to be protected for. An easy example is we have a health tech startup. So in this situation, there was a health tech startup that shared a proprietary algorithm with potential partner without an NDA. Essentially something that was key to their whole business. The one formula, the one algorithm that was essential for their business taking the next steps in growth to being able to scale completely. They shared that information with someone without an NDA, and that partner went and launched a competing product using the same technology, ultimately causing the original startup to lose its competitive edge. And they couldn't prove the theft in court because there was no NDA. And that resulted in a financial loss, damaged reputation, and a loss of market share. So that's just a quick example of when an NDA can help you. And I'm not saying that everyone here is at that level to help startup. It could easily happen to you, depending on what your idea is. You just want to make sure you don't put yourself in a position where someone takes your idea and runs with it, and you're left looking behind thinking like, man, if I only had an NDA. Next, we'll jump to, vendor service agreements. So these agreements are usually used when you're engaging with vendors, freelancers, independent contractors, mom and pop shops, less experienced personnel. Ultimately, if they are an experienced company, they're going to have their own agreement. Either it'll be a master services agreement or it'll be an independent contractor agreement. But this is more so used when there's someone who you're working with who is less experienced, or someone who just also mainly uses handshake deals and never thought to, put the terms of the relationship down on paper, put it in writing. You want to use this to clarify exactly what this person is doing for you, what items they owe you, the deliverables, the timelines for when they actually are supposed to pay you, and the payment terms. You also want to make sure that you have a solid service description. You want to be very specific as far as what services they're actually providing you. If there's a payment schedule, when you're actually supposed to pay them. And probably some of the biggest and more important clauses are the warranty section, the termination clause, the indication, and support. With warranties, these are promises that both parties, you and the other side, are making to each other as far as how you're going to navigate the relationship, as well as things that both people need to do before the relationship can start or for the relationship to continue. uh, the termination clause. What happens if you need to terminate the agreement? Who can terminate the agreement? For what reasons can you terminate? Indemnification is so important. If you do something wrong, you may have to step into their shoes to protect them. Same way, vice versa. If they do something wrong, and it doesn't even have to be on purpose. It could be negligent. It could be on accident, or maybe they intended to do this wrongful deed. If it affects someone who's at your event or someone who's using your services, based off of the actions that they did, they are going to be required to come in and protect you and save you from that lawsuit, depending on a few other factors. But that's the whole spirit of the clause, is to make sure that if they do something that affects you and it was solely as a result of their actions or someone who is under their control, it's their job to come in and protect you. And enforcement are typically essentially what happens if there's an act of God, if there's a random event, if there's a pandemic, if there's something that no one could foresee coming and if that needs to be rescheduled. What happens between you two? What happens with the relationship? And common mistakes are missing a vague scope of definitions. So let's go ahead and look at an example of when someone didn't have a vendor agreement and ultimately things didn't work out for them. So here, e-commerce situation. So there was no formal service agreement between uh, the entrepreneur and a third-party developer. Now, the third-party developer, you could say, is Google, Amazon, Spotify, or just a delivery service. So what happened here? The developer missed deadlines. They delivered poor quality, and then they demanded higher pay. This affected the launch timeline because the developer missed their deadlines. The timeline fails, and customer trust eroded, and it led to financial losses. The end result: business was forced to pull back from market expansion. So this all happened because there was no vendor agreement, because there was no formal vendor agreement. None of the deadlines were set in stone. So the developer felt like they had a little bit of leeway. Oh, sorry, can't get to you Monday, how's Friday? Versus if they had a contract in place, they probably could have held them to that Monday deadline. Or they could have held up the standard of the quality of work because that also wasn't defined in the vendor agreement. And it could have also limited their ability to demand higher pay because the payment schedule and the payment amount wasn't established. So these are just a few common mistakes of what happens when you're working with a third party, someone who you're hiring to do services on your behalf that you will ultimately own or use within whatever campaign or event or project that you're working on. You want to make sure that that relationship, the terms of that relationship, is solid, fortified, and protected. Now we're jumping into the contract. So for this, use this when you are the freelancer who's being hired. You are the consultants being hired. If it's a project-based worker, and this also works both ways. If anyone wants to hire you, you should always use your own template when in your own template agreement when possible. This is to say that most companies are going to hire employees, but if they are hiring an independent contractor, then they're going to have their own agreement. Those are the big companies, but not everyone does. And even when you're working against a company, at the very least, you should try to have them use your independent contractor agreement. Because worst case, if they say no, they're going to have a lot more respect for you. They're going to see that you're a serious business individual, that you know what you're doing. You have your own agreement that has been looked at by an attorney, has been worked on, and it essentially establishes what your standards are. Independent contractor agreements, there is no necessarily custom agreement. It really is something that is negotiated heavily, and it really defines the standards and the requirements of the individual who uses it. So any agreement can be negotiated, There's no set in stone, hey, this is what it is. That might be a stance that a company takes, but ultimately any agreement can be negotiated. It really just comes down to your negotiating power. If you have strong negotiating power, you can take your shot at trying to negotiate anything. And if you don't have much leverage, if your leverage is weak, then yeah, you might be stuck accepting whatever they offer you. But it really comes down to that. So if you're in a scenario where you do have leverage, or you're in a scenario where the other side doesn't have an agreement, a standard agreement in place, then definitely use your own. This is going to clarify the nature of the relationship and avoid any misclassifications as an employee. It's going to clearly define the scope of work, the payment terms. If there's any intellectual property involved, this is going to go ahead and protect you, as well as termination rights. Um, Common mistakes, not addressing IP ownership or work for hire clauses. If someone is hiring you to produce a work and they're going to go ahead and own that work, you want to make sure that's clearly defined. But you also want to make sure that you're going to have the ability to IP for certain circumstances. Essentially, you want to be able to use it for archival purposes. You want to be able to use it for your portfolio, and those are rights that you actually have to ask for. If you don't ask for it ahead of time in the contract before you perform those services, the other side could easily say no when you finally do ask for it. So let's take a look at an example of when someone didn't have an agreement. So there was a freelance designer who was hired without a formal agreement, and there was a dispute over the intellectual property rights for the creative assets. The branding campaign ended up getting pulled, and it was costly rebranding required, and market share was lost. Essentially, because there was no formal agreement as far as who owned the creative assets that were being created, there was a legal dispute, and because of this dispute, the brand was forced to pull the creative assets from the market. It wasn't intentional. It wasn't necessarily on purpose, but it ended up happening. And the ultimate result was time was lost, customer confidence damage, and financial setbacks. If you're a company, anytime you have to take a campaign off, you lose confidence from your customers because they're questioning, hey, what's going on? And the same vice versa. If you are the creative designer, anytime you start a campaign and you hype up this campaign that you're doing, and next thing you know, the campaign falls through, you're the one who ultimately loses. So then there's partnership agreements. So for partnership agreements, these are agreements that essentially, if you are launching a startup with co-founders or partners, especially family and friends, you should have an agreement like this in place. It's going to outline the ownership stakes, the responsibilities of parties, what profit sharing, if any, and dispute resolution. Essentially, if something goes wrong, if you guys have to split up for whatever reason, it's all going to be defined in the agreement. So there's no guessing, there's no fighting. Key terms are going to be capital contributions, decision making, and exit strategies. And the best practice is define the roles and decision-making authority very clearly. Here's an example. You had two founders who launched a startup without a partnership agreement. Eventually, disagreements arose over the roles of the two individuals and what the profit sharing was going to be, and ultimately who had the final decision-making power. This led to legal disputes, and ultimately it led to the business dissolving. There was a dissolution, the partners split up, and it was a complete loss of the company due to unresolved conflicts that could easily have been avoided. Now, those are the kind of conflicts that every entrepreneur, every business, every creative influencer should start with. It really depends on the level of your business. Not every contract makes sense. And like I mentioned before, depending on who you're working with, on the other side, they may have their template agreement. That being said, you should always have your own template. You should never rely on someone else's agreement to protect you, because if anyone has an agreement, it's to protect them. So you may be thinking like, well, why do I need my own? Why do I need my own agreement when I know the other side's just going to say no? Because, I mentioned this earlier. By having your own agreement, you tell the other side that you're prepared. You tell the other side that you're not someone that they can just walk all over. You're not someone who just doesn't understand the business world, because you have your own agreement and you would prefer to use your own agreement. And then it just comes down to your leverage. Depending on your leverage, you may be able to get them to use your version of the agreement. If you don't have a lot of leverage, like I said, you're going to be forced to use theirs. That being said, having that leverage goes such a long way, and ultimately having the respect of the other company as an individual who knows what they're doing, it goes an even further way during the business relationship. And most times, you're going to be working with someone, if you're really starting out new, who doesn't have an agreement, and having something in place that makes you feel peace of mind, that makes you feel comfortable, that makes you feel as if you could take a chance, you could take a risk on someone, because ultimately the paper is going to protect you. That is another reason why you should have your own contract templates. So what are we doing here? Here right now, it's quarter three of the year. Quarter three, most have new money coming in. There are new business opportunities. It's the beginning of the new fiscal year. So there's a lot more opportunities now than there were in the beginning of the year. now companies are quickly moving. They're already taking their new fiscal money and deciding what to do with it for the next year. So I wanted to create a lifeline for those who want to take advantage of quarter three. Obviously this is a service that needs to be had year round, but that's not always the case. You don't always have this opportunity, but this opportunity presented itself now. So I wanted to, do something to help those out. There are plenty of entrepreneurs, plenty of small business owners, influencers, athletes, creators who have great ideas, great concepts, and they just need a little bit of help. And majority of the time, when you have a small budget, legal help is the one thing that gets cut because you're thinking, I can figure it out. There's ChatGPT. And while ChatGPT is a great tool, it shouldn't be the end all be all because ultimately you still don't know what you're looking at. And you don't know if what ChatGPT is giving you is actually accurate. And ChatGPT will be the first one to tell you they're not a lawyer. So if you want to take advantage of the opportunity, if you want to feel protected, if you want to have some templates in place, if you want the other side to truly, respect you and have a little extra leverage on your end, grab one of these contracts, any of the ones that we discussed today, outside of the partnership agreement, just because there's no way I could do a partnership agreement for this cost. I'm sorry, it's very involved. It's very, very involved. And there really is no such thing as like a template. We'd have to have a conversation, but an independent contractor agreement, a non-disclosure agreement, or a vendor services agreement, those are all available right now. You can go ahead and purchase it for about $100. So for that, thank you for your time. And, I look forward to serving you. I look forward to working with you. And ultimately, I wish you luck. It's a great opportunity this quarter. Take advantage of it. Take care and we'll talk soon.